The title of what I'm talking about is the International Law Ramifications of the Glenister Litigation in Search of Effective and Efficient Anti-Corruption Machinery of State. Now, perhaps I should start by describing the Glenister litigation in broad terms, just to put it in the context of what we are talking about here. Glenister litigation consists of 3 cases that were taken all the way to the Constitutional Court by way of appeals in public interest litigation, in which Bob Glenister was the applicant on his own in the first 2, and with the Helen Suzman Foundation in the third one. And all 3 cases concerned the duty of the state to have effective and efficient anti-corruption machinery. In the first case, Mr. Glenister was told that he jumped out of the starting blocks too early, that it was premature to ask the court to give its opinion about what was going on when the Scorpions, or DSO, were being disbanded, and that he should be patient, he should participate in the legislative process that was necessary, and that if he was not happy with where he found himself at the end of that process, he was invited by the Chief Justice Langer to come back to court with whatever complaints he had. But he wasn't happy with the introduction of the DPCI, which we all know are the Hawks, we know them as the Hawks. Because the way that things worked, when the Scorpions were closed down, the investigative functions in respect of serious corruption were given to the Hawks, and the prosecutorial functions were left with the National Prosecuting Authority, or NPA, as we all seem to know that. So, when he went back in 2011, in this case, his judgment has already had its bar mitzvah, it's 13 years old, and he was successful by a majority of 5 to 4 in what is now known as Glenister 2. 5 judges agreed with him that South Africa's international obligations and our justiciable Bill of Rights make it necessary for government to put in place adequately independent, effective and efficient anti-corruption machine. So he won the case on the narrowest possible margin. The 9 judges sitting, there'd been 8, and one of them, the majority, was not present. He would not have won the case because the lower court had said, you're out. Procedurally, that means he would not have got over the threshold of persuading the necessary majority. 5-4 is in fact the tightest majority you can get, because that court has a minimum quorum of 8 judges. So, having won, Mr. Glenister proceeded to lobby for the retention of the Scorpions. He failed in his lobbying, and new legislation was put on the table, brought into law, in response to the court ordering Parliament to clean up its act around anti-corruption. Immediately that legislation landed, Glenister 3 began with the Helen Suzman Foundation, which had been a friend of the court, and Glenister 2 joining in the fight in the third round. And in the third round, the majority judgment in Glenister 2 was accepted and endorsed. There was an argument about what the meaning is of saying it's not unconstitutional in itself to put your anti-corruption machinery in the police. The one judge who had written the judgment saw it one way, and the other judge who written the judgment saw it the other way. So they actually disagreed with each other, having agreed on setting up the STIRS criteria in Glenister 2. Glenister 3 was also a bit of a more Sorry, is that a word? It's defamation. Remorse because the majority of the judges were not prepared to have regard to expert evidence which came from the University of Stellenbosch and from the Institute for Security Studies, which basically said it's not a good idea, given who Jacob Zuma is, who the members of his cabinet are, and the similar corruption in the police, to put your anti-corruption machinery inside. They weren't even prepared to look at that. Perhaps they thought it was poor form to suggest that the man who and appointed them to wear a green robe should be described as corrupt and bad. So Mr. Glenister was accused of odious political posturing in the case, and his evidence to suggest that it wasn't a good idea to put the anti-corruption machinery in the police was not accepted. The court tweaked the legislation a little bit more in ways that it made no difference at all, because now, with the benefit of hindsight, we know that Mr. Glenister should have won in Glenister 1 because there were exceptional circumstances which if evidence had been available, would show that getting rid of the scorpions was part of the state capture. In fact, it was the first step in the Zuma state capture project. And certainly with the STIRS criteria and the need for independence, what we deal with today is more or less because there is no independent anti-corruption machinery in South Africa with the work provided between the police, special units, and the prosecuting authority. Now, let me refer you to paragraph 166 of the second Glenister case. This is the joint judgment. Please don't become confused. The main judgment says Glenister was not entitled to any. The joint majority judgment says that Glenister was entitled to succeed on the international law aspect and the human rights aspect, and was therefore entitled to send on back to reconsider its position in relation to the structure of anti-corruption machinery. This is how the two judges, Moseneke, who was the Deputy Chief Justice, and Cameron, described the need for proper functioning anti-corruption machinery. They say, there can be no gainsaying that corruption threatens to fell at the knees virtually everything we hold dear and precious in our hard-won constitutional order. It blatantly undermines the democratic ethos, the institutions of democracy, the rule of law, and the foundational values of our nascent constitutional project. It fuels maladministration and public fraudulence, and imperils the capacity of the state to fulfill its obligations to respect, protect, promote, and fulfill all the rights enshrined in the Bill of Rights. When corruption and organised crime flourish, sustainable development and economic growth are stunted, and in turn, the stability and security of society is put at risk. And if we put that in its historical context, we can see that the world order that was established in the wake of the devastation of World War II, by the formation of the United Nations, was aimed at creating peace that is secure, progress that is sustainable, and prosperity that is equitably shared. There's an aspiration for worldwide respect of the Universal Declaration of Human Rights, which was originally published on the 10th of December 1948, and in which South Africa had, at that time, quite a big hand via Jan Smuts, who was a field marshal in World War II, and also on the other side of the World War. So, the South Africans have caught up with that international declaration to the benefits of a more comprehensive Bill of Rights, a modern Bill of Rights, which is Chapter 2 of the Constitution. I hope you all carry your constitutions around with you, and that you put it under your pillows at night before you close your eyes. Our Bill of Rights came into force on the 4th of February 1997, which is quite a long time after the 10th of December 1948. Corruption in its many and varied manifestations is a worldwide scourge and a threat to human rights and their proper realization. Nations of the world have taken steps to deal with corruption. Since December 2005, there's been a legally binding universal anti-corruption instrument known as the UN Convention Against Corruption. 185 countries are party to that convention. In Africa, the AU, you all know what AU means now, has a convention on preventing and combating corruption, which entered into force on the 5th of August 2006. According to a communique from the AU in February last year, 48 out of the 55 countries in Africa have acceded to and adopted the AU Convention, while a 49th country has signed the convention without yet adopting it. As there are only 55 countries in Africa, the convention could only notionally apply to a handful of extra countries. It can be seen that the scope and purpose of the anti-corruption treaty is widely accepted, at least on paper in Africa. Under Article 5.3 of the AU Treaty, an obligation is created that is all too often honoured in the breach of the domestic laws of the countries that are party to. The obligation is in the form of an undertaking by parties to the convention. They undertake to establish, maintain, and strengthen independent national anti-corruption authorities or agencies. The entities thus established, maintained, and strengthened, if they truly enjoy both structural and operational independence, ought to be in a position to prevent and combat corruption in all its forms. It is not the case in Africa and elsewhere in the world where similar undertakings have been given. This is an indication of a failure to honour obligations seriously entered into in the applicable conventions and treaties. And in South Africa, we've domesticated our obligations, both under the UN and the AU anti-corruption instruments. Foremost among the international instruments containing undertakings of this kind is UNCAC. Most African countries have acceded to UNCAC. Its provisions are along the same lines as those contained in the AU Convention. In terms of Article 6.2 of UNCAC, undertaking not unlike Article 5.3 of the AU Convention is solemnly made by signatory states and is also honoured in the breach by many of them. Article 6 is important, so let's give it to you in full. 1. Each state party shall, in accordance with the fundamental principles of its legal system, ensure the existence of a body of bodies as appropriate that prevent corruption by such means as A. Implementing the policies referred to in Article 5 of this convention, and where appropriate, overseeing the coordinated implementation of these policies, and B. Increasing and disseminating knowledge about the prevention of corruption. 2. Each state party shall grant the body or bodies referred to in paragraph 1 of this article the necessary independence in accordance with the fundamental principles of its legal system to enable the body or bodies to carry out its or their functions effectively and freely of any undue impact. The necessary material resources and specialized staff, as well as the training that such staff may require to carry out their functions, should be provided. This is not me making it up. This is what's in the convention. 3. Each state party shall inform the Secretary General the name and address of the authorities and so on. So, When UNCAC appeared on the scene, the Secretary General of the United Nations was Kofi Anow, and he said something important to mark the occasion. The adoption of the new convention will be a remarkable achievement, but let us be clear, it is only a beginning. We must build on the momentum achieved to ensure that the convention enters into force as soon as possible. I urge all member states to attend the signing conference and to ratify the convention at the earliest possible date. If fully enforced, this new instrument can make a real difference to the quality of life of millions of people around the world. And by removing one of the biggest obstacles to development, can help to achieve the Millennium Development Goals. They've been replaced by the UN SDGs that we were talking about at question time. Be assured that the United Nations Secretariat, and in particular the United Nations Office on Drugs and Crime, will do whatever it can to support the efforts of states to eliminate the scourge of corruption from the face of the earth. Big challenge, and I think that together we can make a difference. You're asking yourselves how, in 2024 and beyond, can African nations build on the momentum achieved in the anti-corruption arsenal assembled in Africa. Regional treaties and protocols do exist in various parts of Africa. It's unnecessary, for present purposes, to drill down into them, because the basic obligation to create and maintain independent anti-corruption regime of state remains intact at all times and at all levels. The how-to question is most vexed in countries in which democracy and the rule of law are least embedded. All too often in Africa, the big man syndrome is in evidence. Presidents for life proliferate, coups and rigged elections dot the political landscape, and war is an ever-present threat in some regions. The specters of authoritarian nationalism, even tribalism, remember 100% Zulu vote, threatened in some regions. They bedevil all attempts at building an anti-corruption culture in Africa. The political will, and that's the most vital part of the whole story, the political will to do so has to be cultivated and protected if the forces of crime and corruption are not to prevail. This vital task involves respecting the rule of law and acknowledging and implementing the doctrine of the separation of powers that is so central to the checks and balances on the exercise. Those checks and balances are absent in authoritarian systems bent on exercising hegemonic control over all levers of power in society. Question time, because I need a drink. What does NDR stand for? Put up your hand if you don't know what NDR stands for. I've just read out the clue. NDR stands for National Democratic Revolution. It's aimed at securing hegemonic control of all levers of power in society. It's what gets the ANC out of bed in the morning. You can see what I'm struggling. The voters should take care to vote for politicians who prioritize service to the people who elect them, rather than regard career politics as a means to rapidly amass unearned wealth. The South African experience since Uhuru, that's the South African experience in the last 30 years, is instructive. In the biography of Thabo Mbeki, his biographer, Mark Kafissa, recalls in The Dream Deferred the fears that dogged Mbeki at the end of his second term puts it thus, writing in 2007, when Mbeki was approaching the end of his second and last term of presidential office, and before Zuma had won and qualified, says, Mbeki was deeply distressed by the possibility of being succeeded by Zuma. He believed his deputy's play for the presidency to be part of a strategy to avoid prosecution. Mbeki allegedly worried that Zuma and his backers had no respect for the rule of law and would be unaccountable to the constitutional dispensation. There was also a worry of resurgence of ethnic politics and, given his support from the left, that Zuma's leftist advisors would undo all the meticulous stitching of South Africa into the global economy that Mbeki and his economic managers had undertaken over 15 years. The possibility of a Zuma presidency was the scenario far worse than a dream deferred. It would be, in effect, a dream shattered irrevocably as South Africa turned into yet another post-colonial kleptocracy, another footprint of despair in the path of destruction, away from the promises of rule. Well, history reveals that not one but two terms of Zuma presidency was forced upon us. The state capture project on his watch, and many other footprints of despair along the way, have been our history in the current president calls the 9 wasted years. Too many actors in the South African political firmament are wedded to the politics of the stomach. One, now ambassador to Japan, Smuts Ngonyama, famously admitted that I did not join the struggle to be poor. That's what he said. At the time of his election, Zuma was quick to move against the anti-corruption Scorpions unit, the South African National Prosecutor, which was then within the South African National Prosecuting Authority. It had been a thorn in his flesh. Through successful charges of corruption, it preferred against Zuma's personal financial advisor, Shabir Shaikh, who was duly convicted of corrupting Zuma in 2005. The related criminal case against Zuma is still pending in 2024. He has mounted the Stalingrad strategy of delaying tactics and maneuvers that have kept the prosecution on the back foot over as many years as both civil and criminal litigation. Civil litigation, I'm pleased to say, ended on my birthday in 2017, when the Supreme Court of Appeal ruled that the decision of the acting National Director of Public Prosecutions not to prosecute Zuma was invalid, set aside, and prosecution was revived. The Scorpions were dissolved in 2009 at the instance of the Zuma-led majority party. In their place came the Hawks, a mere police unit tasked with the investigation of priority crimes, including serious corruption. The Hawks have been through 3 different incarnations in the statute book of South Africa. In its seminal Glenister 2 judgment, the original form, that's the concourse Glenister 2 judgment. The original form of the Hawks was struck down as unconstitutional for want of compliance with international obligations of South Africa under Article 6 of the CAP, and because it would be impossible for the South African state to honour its obligations under Section 7.2 of the Constitution to respect, protect, promote and fulfil the human rights guaranteed by law. That can't happen if you don't have effective and efficient anti-corruption machinery, because the corrupt take the money that is meant to service the population, to lift the poor, to educate the children, to heal the sick, and they invest it in faraway countries in numbered bank accounts. So the finding in Glenister 2 that the original incarnation of the Hawks did not pass constitutional muster was due to their lack of independence and lack of sapiential authority. The simple word for sapiential authority is clout. You don't have clout, it's quite hard to go after important people who have painted outside. So Parliament was ordered by the Constitutional Court to return to the drawing board to devise a new legislative framework that would set up a system in which corruption would be counted effectively and efficiently. Under the domination of Zuma, all the while busy with state capture, Parliament did as little as possible to tweak the legislation creating the Hawks. It did so by September 2012, which was the last month that the court gave Parliament to do the work. The constitutionality of the second incarnation was also challenged with limited success. The court edited the remedial legislation that did not properly remediate the lack of independence of the Hawks. In November 2014, the court issued an order confirming Glenister 2 and incorporating the changes it needed to create the Hawks' third incarnation, which is what we have now. In the 10 years since 2014, the Hawks have not succeeded with the investigation of any big fish involved in serious corruption, by which I mean politically exposed persons or politicians, the powerful, big fish. Their investigation, those fingered by the Zondo Commission of Inquiry, has been both patchy and scant. Yesterday in Parliament, the President told the House, National Assembly, that these things take time. But what he didn't say was that they take considerably more time if you do not capacitate the anti-corruption machinery in the way that the court requires. Prosecutions have failed. Matters have been struck from court rolls for want of proper timeless investigation. And the flagship Ulana case is currently on appeal after the prosecution faced the ignominy of a discharge of the accused at the end of the state's case. The ruling in the Constitutional Court in Glenister 2 still stands, not been properly implemented by the government of South Africa. Had it been, the state capture project would have been nipped in the bud, and the economic and developmental prospects of South Africa would have been considerably enhanced. Instead, after the end of the Zuma era, which stretched from 2007, when he won at Party, to 2018, when on Valentine's Day he was forced to resign. The value of the rands continued to slide from around 11 to the US dollar in 2018, when Ramaphosa took over Zuma, to around 18 rand to the dollar now. And for currently, South Africa pays out about 2 billion rand every day to service our national debt. Corruption is still rampant in South Africa. It did not have to be so. The proper implementation of the Glenister decisions, which are binding on government, could and should have ended the kleptocracy and the patronage involved in state capture, tender premierism, COVID premierism, and all of the kakistocratic maneuvers that relieve the public purse of money in illegal ways. The Glenister case findings are a gift to any country with a justiciable bill of rights and a commitment to the obligations under the AU Convention. Provided there is a robust, impartial, and independent judiciary available to public interest litigants, the route taken by Glenister is available to them in most countries in Africa and all 48 that are parties to the UN Convention. In essence, the litigant succeeds on 2 points: assailing the constitutionality of the legislation that created courts, invoke the treaty obligations that I read out to you, and of course there's the SADC protocol against corruption as well. Relying on the breach of those obligations, sought relief striking down the legislation in question as unconstitutional due to the breach of the international obligations assumed when South Africa acceded to the treaty instruments in question. The duty to establish and maintain independent anti-corruption machinery was found by the court to have been breached and to have been an infringement of law and by human rights. It found the government was in breach of the duty to uphold human rights because the diversion of public funds to those involved in corruption served to cripple proper service delivery in respect of the rights of humanity. The court found that Glenister on both of these points. Its reasoning is contained in the joint majority judgment, which is in the big fat book over there. There's no reason for litigation similar to that embarked upon by Glenister not to be mounted in any jurisdiction in the world in which there is a justiciable bill of rights. Any treaty obligations of the kind mentioned above, and a limping the criminal justice administration that is incapable of protecting the people against it. Independent and fearless judges will give impartial consideration to a case that relies upon the 2 points of law on which Glenister succeeded, will order governments to adjust the law by making the reasonable decision of a reasonable decision maker in circumstances when amending the law to achieve constitutional compliance. Governments do not comply with such an order. The public interest litigants can do what Glenister did: return to court additional relief to receive. The incomplete or partial implementation of court orders can be cured by seeking declaratory and mandatory relief, which may be accompanied by a supervision order designed to keep the remedial work within constitutional bounds. It's also possible, when true recalcitrance is in evidence, to invoke contempt of court proceedings as a remedy for failing to establish the anti-corruption machinery that ticks the boxes created in the international instruments and in the STIRS criteria laid down by the majority of Institute. Now's the time to wake up and take note. STIRS stands for Specialized Anti-Corruption Work of all kinds, preventative, combative, investigative, and prosecutorial. T stands for train, to a level that is on par with the firepower of the corrupt, who can harness senior counsel to represent the court. Independent, both in operations and in structure, of the anti-corruption machinery. That means free of influence, interference, impedance by the executive. If you are independent, the executive ought to leave you alone, and your structure and operations ought to reflect. R is for resourced, adequate and guaranteed fashion, so that kleptocrats cannot shut down anti-corruption work. That is what is happening in South Africa at the moment. Deflecting furiously in Parliament yesterday afternoon, the President said, these things take time. The reason why they take time is because the critics in his cabinet don't want them to happen anytime soon, and the institutions that are meant to be doing the necessary work are just kept under-resourced. infested with saboteurs, and do not have the clout to do the job anyway. In South Africa today, moves are afoot in opposition circles to introduce a new Chapter 9 institution, and is tasked with preventing, combating, investigating, and prosecuting serious corruption. All institutions set up under Chapter 9 guarantee their independence in the Constitution itself. They exist to bed down constitutional democracy. That's what the subheading of Chapter 9 says. Their reporting lines are to Parliament, not to the executive branch of government. They are insulated against any executive involvement in their duties. They are, under the constitutional dispensation of South Africa, the type of institutions best able to tick the independent box that is set up in our treaty obligations and in the binding judgment of the Constitutional Court. The truth is that it's extremely difficult to dislodge kleptocrats. Once established, they tend to defeat protection that is afforded to them by deviations of the system that they set up to keep themselves insulated as possible for their corruption. In South Africa, the NPA has been hollowed out by state capital. Its current leadership complains in public that the authority is infested with what they call saboteurs. These are people planted there to disappear dockets and trip up people trying to do a good job on corruption. The saboteurs continue to enjoy impunity against all forms of redress, including criminal prosecution and civil proceedings. Opening words of the last Glenister case, known as Glenister 3, the one where the System Foundation was well, and moved separately with the two cases we had together. The System Foundation did not try to move the Hawks out of the police service. They simply addressed the technicalities that stirs compliance. Listen to what Chief Justice Queng said when he fired off in the third case. All South Africans across the racial, religious, class, and political divide are in broad agreement that corruption is rife in this country and that stringent measures are required to contain this malady before it graduates into something terminal. We are in one accord that South Africa needs an agency, not a selection of agencies, an agency dedicated to the containment and prevention and eradication of the scourge of corruption. Also agree that this entity must enjoy adequate structural and operational independence to deliver effectively and efficiently on its core mandate. All's well. I'm done.
Thank you. Thank you very much. I don't have time to give you a proper thank you